My name is Nishtha and I will be talking about appeals to Supreme Court. So Supreme Court enjoys various jurisdiction like advisory jurisdiction, jurisdiction, original jurisdiction and appellate jurisdiction. So under appellate jurisdiction, anyone can approach to the Supreme Court when he is not satisfied with the decision that is given by the lower court. However, there are certain conditions which need to be satisfied before one appeal to the Supreme Court. So, what happens is, first of all, the case must be judged by the High Court against which one is appealing in the Supreme Court. Moreover, the High Court thinks it fit that the case is competent enough to be tried at the Supreme Court. Also, if the Supreme Court itself thinks that this case involves a substantial question of law and hence it should be tried in the Supreme Court itself. Now, talking about the criminal matters that could be appealed in the Supreme Court. First of all, there are various conditions here also that need to be met. First of all, the High Court must certify that this case is fit enough to be tried in the Supreme Court. Also, the case could be that the High Court has withdrawn before itself from the trial. The High Court has reversed an appeal. However, it must be kept in mind that no appeal could be made in the Supreme Court against a case in which the High Court has given a decision and a sentence of not more than 6 months or a fine which does not exceed rupees 1000. Moreover, a criminal appeal could also be filed in the Supreme Court against the decision that is made in the High Court if it could be proved that the High Court misapplied or misconstrued the facts and the laws of the case. Moreover, after getting the certificate of fitness from the High Court, the case must be appealed in the Supreme Court within 60 days, or it could be appealed within 60 days from the final order. However, the time that is spent for obtaining the copy of judgment, it must be excluded from that 60-day period. However, if there is sufficient cause for delay, then it could be told to the Supreme Court, and if it finds it satisfactory, then uh, it could admit the appeal. Now, coming to the constitutional matter, since the Supreme Court is regarded as the guardian of the Constitution, and hence all the cases which involve a substantial question based on the constitutional matter must be referred to the Supreme Court. Moreover, in this case also, the High Court must think it fit that it is necessary for the case to be tried in the Supreme Court. Now, coming to the civil matters, before diving deep into this topic, it is important to know the difference between judgment, order, and decree, which forms an essential aspect under this topic. So, judgment is based upon order and decree, and it is a very important part because it forms a part of the future precedents. Now, coming to order is a formal expression, but it is not a degree. So, order contains a formal discussion on the question of law that is to be dealt by the court. Moreover, it also involves the rationale behind giving a certain decision. Now, unlike order, decree is a formal expression made by the court. It describes the rights of the party, and decree could be of three types, which could be a final decree, a preliminary decree, or partly final and partly preliminary. Now, one of the most important aspect under this whole topic, that is appeals to the Supreme Court, is the substantial question of law. So, substantial question of law is nowhere defined in the court. However, it must be construed from the facts and it varies from case to case. Moreover, it must be kept in mind that whatever is the substantial question of law, it must be for the benefit of the general public. It should not be confined to a particular case. However, it must be for the benefit and it should be used as a future precedent. Moreover, one of the important aspect is certificate of fitness. It is given by the High Court in cases where it thinks fit that the case is important enough or the case is competent enough to be tried in the Supreme Court. it must be given in two conditions. First of all, that I mentioned before, that if the High Court itself thinks it fit that this case should be tried in the Supreme Court, or if the case involves a substantial question of law, and in this case too, the case should be tried in the Supreme Court. Now, talking about special leave petition, it is one of a significant portion under appeals to the Supreme Court. Under Article 136 of the Indian Constitution, uh, the Supreme Court gives special leave to an aggrieved party to file appeal against the other party. In real sense, it is not an appeal, it is a leave to make an appeal. So in this case, what happens is the aggrieved party moves to the Supreme Court, and the Supreme Court hear the argument of both the sides, and if it thinks fit, then it allows the party to make an appeal in the Supreme. And now I will be talking about procedure at hearing. So, under Rule 7 of the Criminal Procedural Code, the provision of security is given. In security, after the final order has been given by the High Court, uh, for which the appeal has to be made in the Supreme Court, after 90 days from that final order, or after giving a sufficient cause, after 60 days from that final order, the security has to be deposited to the Supreme Court. The security can be given in cash or in government securities. This security is actually used for all the expenses that the court has to bear for the appeal that is made. For example, the copy of the judgment, the translation that has to be done, and other such expenses that the court has to bear with regards to the appeal that is made. Moreover, the Supreme Court can also demand the security from any person who is living outside India and he does not have any immovable property inside India that could be attached with that order. So, he or she also has to provide or give any security to the Supreme Court. The court may also, after a given point of time, can revoke the security and give further directions. Moreover, the court, if it finds it inadequate to function with the given security, it could also give direction to give further securities. But the direction has to be given after the admission of the appeal and before the transmission of the record. Moreover, the court can also order for further securities, keeping in view and considering the hardship that is faced by the opposite party. The time for furnishing the further security has to be specified by the court. These rules regarding the further securities are present in Rule 9 and Rule 10 of the Criminal Procedural Code. Under Rule 8 of Civil Procedural Code, it is mentioned that after the payment of security, the Supreme Court, if it deems necessary and if it deems fit, it can admit the appeal. While admitting the appeal, the Supreme Court has to send a notice that the appeal has been admitted. It also has to send the notice to both the parties. Moreover, it also has to send an authenticated copy of the papers of the suit if the expenses for the same has been paid. Moreover, transmit the same on the seal of the court and other authenticated papers. Under Rule 13 of the Civil Procedural Code, it is mentioned that the court can transfer the power of pending appeal if the parties are interested. Also, in special cases like impounding any movable property in dispute, stay the execution of the decree appealed from, or if it has taken security from the party, then it has to give the judgment on the same. Now, talking about the appeal, the provision of appeal from the Constitution, uh, it is present in the Article 132 that the appeal from the High Court can go to the Supreme Court in cases of civil or criminal suits. In Article 133, it is present that the appeal can go from the High Court to the Supreme Court in cases of civil proceedings. Moreover, 133 also specifies that the appeal could be made to the Supreme Court only if the High Court deems it fit. Also, Article 136 provides a very significant aspect, which is special leave uh, petition. In this, the party is given a leave to appeal, and this is not an appeal but a way to appeal. Now, coming to the conclusion, Supreme Court is the apex court in the country. It enjoys appellate jurisdiction, and it is primarily the court of appeal. It is also the highest forum for appeal in the country, and it is also important to know that appealing in the Supreme Court is not a matter of right but a matter of privilege. There are various conditions under which the appeal in the Supreme Court can be made. One of the most important is after getting a certificate of fitness from the High Court. There are various constitutional articles that provide for appeals in the Supreme Court, and also there are various sections that are present in the Civil Procedural Code for appealing in the Supreme Court. Thank you.